Okay everyone, welcome back to Real Attorney Plays Ace Attorney, Episode 2. I am the Mighty Ethan. I am a real attorney, as noted in the title. I am a prosecutor with the state of Kansas. I am playing through Ace Attorney, Phoenix Wright Ace Attorney Trilogy, to see how it compares to real life. I've never played these games before. If you missed episode 1, go back and check it out. I'll put a link on the screen if I can figure out how to make YouTube do that. Otherwise, it should be easy enough to find on my profile. I'll have a playlist set up with all these episodes. Last time I just flashed it on the screen, but I do want to say all the information contained in these videos is for entertainment and educational purposes only. It's not legal advice. I am an attorney, but I am not your attorney. So don't take any of this as legal advice. If you have a legal situation, get your own attorney so they can give you advice particular to your situation. With all that out of the way, let's get started on episode 2. Episode 2, The Turnabout Sisters. Okay, so it seems like every episode is probably going to start with us seeing the situation that leads to our court case. I'm guessing these two are sisters, maybe? Maya and Mia? Oh, okay, so... Okay, so this is tying into our last case where the clock, a lady was bludgeoned to death with a clock shaped like the Thinker. So who's this Mia person? Okay, if that's evidence, you can't be doing that. The clock... Oh, okay, so the clock isn't evidence, they're just using it to hide documentary evidence. Okay, I guess right, they're sisters. I hope that time wasn't important because I didn't pay enough attention to it. How dramatic. Murdering the lawyer. Oh wait, was that the lady who helped me in the last trial? Okay, once again, we saw the murderer, so that's good for us to know. Going into it, that always makes things easier. Okay, so we're at the law office. Oh, it's my law office. Okay. I'm a little confused about this evidence situation. Why did we have the clock? Oh no. Oh, okay, so this is that investigation part. Hopefully I don't mess this up too bad. So I guess I'm gonna move to the office. Okay, I suspect that I'm going to end up being an attorney in this case. I should not be an attorney in a case where my own law firm was attacked. That's just a terrible idea. Apologies if you hear my cat. He insists on being in my lap and doesn't like me moving around. So, you know how it is. Not really a lot I can do about that. Okay, so that is the lady who helped me last time. lady who clearly never had it explained proper attire for court. Well, that's just... Alright, I shouldn't be examining things. I should be calling the police, and not doing any... Oh, died instantly. That must have been a really hard hit. Also, I'm not a doctor. I don't know how quickly someone... Unless her whole head was, like, blown open or something, I don't think I can really... Oh, again! So it was the thinker that she was bludgeoned with. That is a double murder weapon right there. Oh right, this is the duplicate thinker, not the same one from the other murder. A piece of paper, what could it be? If I read it. But don't miss clicking by an inch. She wrote Maya. Okay, I shouldn't even have snooped around that much. I've already tampered with the crime scene. Gateway Hotel, okay, that's probably... Wait, I thought I was done snooping around. Oh, okay. Why was that already checked off? I already checked her. Chair's knocked over. Slide? Oh, there we go. Okay. Okay, you kind of have to be at least halfway decent with computers to be a lawyer nowadays, and it, like, lawyers are required to be competent, and that includes being able to use relevant technology, which means it can actually be an ethical violation if you don't keep reasonably up with technology. That's not to say everybody has to be, like, a super tech genius, but you gotta know how to use, like, online research databases. Seems like pretty soon we're going to have to know how to use AI to help us with our research. And if you aren't doing that and in a way that negatively affects your representation of your clients, that could actually be an ethical problem of a lack of competence. So, I mean, this seems like we're at like 90s level technology here, so like a cheapo word processor computer is probably good enough. Probably was not impacting her representation, but alright, I'll call the cops. Oh my. What's with the ladies in this? Oh, I'm gonna have to defend myself now. That's... I'm not supposed to call the cops? Okay. What am I supposed to be? Move. We're gonna go out here. Of course she... Okay, there she is. It's okay, I work here, so I'm perfectly qualified to investigate an apparent murder. Yeah, I don't know what my person is, what we're doing. This is what the police are for. I should have left the room immediately, closed the door, and called the police, and then let them do their thing. They can question me about whatever. But maybe she did the murder. How? Yeah, that... I freaked her out. Okay, I think I had to do that though. I hope I had to do that, otherwise I just really seriously messed this up. Ha. Okay, now, guessing based on my knowledge of fiction, they're probably going to relish investigating me because as a defense attorney, they don't like me. That's not the way things are in our jurisdiction, at least. Like I kind of said in the last video, everybody more or less gets along, knows that everyone's just doing their job. We don't have those kinds of issues. Okay, see, that's right. Yeah, they tell us sit tight. We're gonna... Yeah, that doesn't look good. Okay, that's you're kind of jumping to conclusions, but yeah, it doesn't look good. And again, he's jumping to conclusions, but yeah, probably would hold us for questioning at least while they figured out what was going on. If you find a murder scene, especially this soon after it apparently happened, expect to be stuck there for a while the police kind of try and get a handle on stuff. What doesn't make sense is why Phoenix is not also being detained. But again, at this point, it should just be for questioning, unless they have some other evidence, which I wouldn't know if they did or not, but unless they have some other evidence to indicate that she actually did it, they should have questioned her and then probably released her without, again, unless they have more than just her being there and the note to indicate that she's the one who did it. They would, of course, she would be a suspect. They probably don't leave town, ma'am. But I don't think they would likely actually arrest her based on what we've seen so far. Unless, again, there's more information they have that we don't know about. It's up to her whether she wants me to represent her or not. But again, I should not be a lawyer in this case. My boss was murdered. I definitely should not be defending a suspect, even if I think that suspect is innocent. Like in the previous case, I'm going to be too emotionally wrapped up in this to think about it objectively, and you definitely want a lawyer that can look at things objectively and give you advice about what is best in the circumstances without too much sympathy or any strong emotional feelings about it getting in the way. Oh, this is all about jumping to conclusions. Oh, she's heard about me. She's heard that I've done one trial and that I did a good job. So that means that I should do another murder trial. Totally. Yes, I am very much liking experience. And hit the nail on the head right there. Yes, give me more years. 100%. Yeah, don't hire me unless you... Okay. That's going a little far. I could handle low-level, simple stuff, shoplifting, stuff like that. Because you gotta get experience somehow. But yeah, you don't want to hire a brand new attorney for a murder. I basically lucked into the other one. Nothing about my skills really were what saved that case. So yeah, hire someone experienced if you're charged with murder. You want someone who knows what they're doing. What am I examining? Oh, okay, she's in custody. We're being recorded. Okay. Talk. I wondered the same thing, but I just chalked it up to Japanese game. Okay, what did you do the day of the crime? Now, see, actually this brings up something. I should not be asking... The defendant is a little different, but for the most part, you should not be asking people about the facts of the case without at least someone else there as a witness to your discussion. Because, say she says something, and then later changes her story, now I'm potentially a witness to that, or if she, you know, gets on the stand and says something different, now I know that she's lying, and then that creates a conflict for me, which I kind of talked about in the first episode. If you want to go back and watch that, I talked about it in more detail, but basically I can't allow false information. I can't knowingly allow false information to enter the court record without correcting it. I also have a duty of confidentiality to my client, so if they've told me one thing and then they get up on the stand and say something different, that creates a conflict between those two duties, and basically the only way to resolve it is to get out of the case, withdraw as counsel. So for the most part, you don't necessarily want to be getting facts. Now again, with the defendant, that's a little different, because they're your client. If they say something different on the stand, you can ask for a short break. You can go talk to them in the hallway, try and get them to correct it. If they won't, then that creates a problem. But there are things you can do short of withdrawing. But for other witnesses, say a witness says something to me and then they say something different on the stand, and I want to point out that they said something different before, I'm the only witness to that statement, which means I'm now a witness in the case, which means I can't be an attorney in the case. So you really don't want to talk to witnesses without, ideally you would have a dedicated investigator, even as a defense attorney. Now, obviously smaller areas, smaller firms, you can't afford that, but you want to have somebody else there so that if it becomes an issue, you can put that person on the stand and ask them about what the person said instead of you being the only witness. But again, with the defendant, they're your client, they can kind of tell you what happened. It's a little less strict in that kind of situation. Oh, well, that's handy. Okay, that's accurate. They would take it as evidence. They would want to search the phone, see if there was any conversations between the two of them, any messages that were relevant to the case. So yes, 100% they would do that. Okay, she shouldn't need to write me a note. I should be writing my own notes. If I'm not writing notes, that's a whole other issue. I should be taking very copious notes. If nothing else, you want to cover your own butt so that you take notes about what you do, what you told your client, so that they can't come back after the fact and say, oh, well, he never told me X, or they advised me to do Y, and it's not true. You want to take very detailed notes so that you can defend yourself against that kind of stuff, because people who have bad things happen to them in the legal system that they don't think should have happened like to blame their lawyer for it, so it's good to have the records to cover yourself. Okay, so they're a family of psychics. That's, you know, whatever. Okay. No. That... If you... Okay. So, yeah, I'm not going to sit here and tell my client you're crazy and your whole worldview and career or whatever is BS. I'm not going to do that. But... it's not... There's no point. It's... If we contact the spirit, one, I don't believe it's real, but two, even if I did believe it's real, it's not admissible in court. There's nothing I can do with that information. So yeah, and especially if we contact her spirit through the suspect, that's any information we get from her is obviously going to be questionable at best, and she has a pretty good incentive to lie about what her sister's spirit might be saying. Yeah, see, she's being smart, and I would, as Phoenix Wright in this situation, be like, yes, absolutely, I will take your note to a more experienced attorney who should definitely be handling your case instead of me. And I already kind of agreed to represent her, so I definitely can't refuse to do that, because I can't say, no, you have to have me. Like defendants are allowed to choose their own counsel if they can afford to. If you can't afford an attorney, you get a court-appointed attorney, and it's whoever the court appoints. You don't get to pick. But if you're hiring your own counsel, you always have the right to choose your own. So I can't force her to use only me, and it would be unethical if I tried to. And I keep saying things are unethical. When I say unethical, I don't just mean, oh, it would be frowned upon. I mean, like, you could lose your law license, potentially. You could have other less severe penalties, but there's an actual board of attorney ethics that oversees and deals with those kind of problems. So when I say ethics, I mean like actual rules that people enforce and will punish you for violating. So when I say something's unethical, that's what I'm talking about. So yeah, I cannot refuse to allow her to try to hire other counsel. Okay, so her parents are dead. What? The trial's tomorrow? That is... She doesn't even have an attorney until just now, possibly. This is like Old West style of rush straight to trial. No, we would... I would have to enter my appearance. Her first appearance in court probably wouldn't even be that quickly. Here... You have 48 hours for a judge to review your case, but that doesn't necessarily mean you even have to go in front of the judge. An affidavit from the officers as to why they arrested you and what it's for is good enough. The judge has to review that and set a bond amount. And then you're required to have a first appearance within a reasonable period of time, but that's the only requirement, that it be reasonable. So usually it's within a couple of days. It's usually not the next day. That's a pretty quick turnaround. The prosecutor's office would not have had time to get and review the reports and file charges. They would not have had time to get them on file with the court, which would be necessary to do a first appearance. At the first appearance, she would be read what the charges are against her. If she hadn't hired an attorney, she would get one appointed at that point. If she was still in custody, then she would be able to ask to have her bond reviewed, which doesn't necessarily mean it would be changed, but it would at least be addressed. And then if she had hired an attorney at that point, they would just now be getting into the case. They would need to be getting all the information from the prosecution about what the case is about. There would be a lot that has to go on, even for a first appearance. So usually, first appearance, say she's already hired counsel, we have a first appearance. The second appearance, so we would just say we need to get started on the case, basically, and the next appearance wouldn't be sooner than a week after that. And that's just kind of... 6 months is pretty quick for crime to jury trial. That's on the fast side of reasonable. Occasionally we'll get stuff that's faster than that, but that's about normally the fastest it goes. So no, trial is not tomorrow. Yeah, okay, corrective response from Phoenix there. Okay, that's correct, but again, it would not be that quickly. That is not enough time for anyone to prepare for a trial. Even after all that stuff I was talking about, for a murder trial or a rape or something really serious like that, like, I always block out a whole week leading up to the trial just for preparation for the trial, to go over everything, to make sure all my exhibits are squared away, to make sure I have all my witnesses. That's another thing. You have to subpoena witnesses for a trial. That takes time. You have to locate people. You have to. A day isn't enough for a trial. It's not even enough to do a full investigation. The police probably wouldn't even have their full report, even assuming it's pretty cut and dried. Then, and there's not a lot of leads to follow up on and other ancillary information. Then the police would probably have their full report to the prosecution within that first week that I was talking about. But, yeah, that's not enough time for anything to happen. Alright, so I guess I'm gonna go... Okay, I don't need to examine or present her with anything. So let's go talk to the other attorney. Is he a hunter? Okay, that's not unusual. A lot of times, like in my office, I had all kinds of statute books going back literally decades. When I was in defense, our office that we had all of this, what's called the session laws, which are the actual bills passed by the state legislature, had all of those going back to when Kansas became a state originally. So like 130, 140 years worth of session laws, just on shelves, just because they look nice and impressive. Like I don't look at the session laws from 1932. They're just there because it looks official and lawyerly. So yeah, the fact that the books don't look touched really isn't that weird. There would be a few that he would use on a regular basis, such as the current statutes. There'd be some books of case law that talk about what various decisions have been. You would refer to those. But maybe one or two of these horizontal shelves worth of books, and then the rest would basically be decoration. Okay, I guess I don't need to snoop around his office. So this guy's rich. How do I know the plant is expensive? Okay. I guess back. Move. I'll go talk to her again, I guess. How do I find him? Apologies if this turns into a lot of... Detective Gumshoe. Okay. I can't pretend to be her lawyer if I'm not her lawyer. That's not okay. That would be an ethical violation, like I talked about. Also, even if I were her lawyer, I can't be investigating the crime scene. That's not... Yeah, I can't be doing that. It is a crime scene. Is for the... Once the police were done, I could go look at it. But I can't be going through stuff while they're still investigating, because they have to preserve the evidence. They have to make sure nobody changes anything, and that would include me. Okay. Let's move. Alright, I don't need special treatment to see the... Yeah, exactly, I need to see the autopsy report. Well, that's nice, I guess, so it's not So horrifying. Prosecutor Edgeworth. Okay, prosecutors like that, there are prosecutors like that that have an extremely high conviction rate. The reason they have an extremely high conviction rate is not because they're necessarily super good in court, although you do have to be good to get all those convictions. But the main reason is that you don't take cases that aren't like open and shut cases. So it doesn't actually really say anything about how good he is at being an attorney. Also, if he became a prosecutor at 20, then we're talking like child prodigy levels here. Typical age for graduating from law school is 25. You have to get a 4-year undergraduate degree first, and then law school itself is 3 years. So you can, without being completely like genius level, you could, if you really worked, squeeze in your what would normally be your 4-year degree into 3 years and be done by 24. But generally speaking, that's the kind of age before you're even out of law school. Yeah, so 20, we're talking like Doogie Howser here, finishing law school by 20. Okay, yeah, obviously there are shady attorneys, just like there's shady people in every line of work. So yeah, if he's forging evidence and stuff, that would contribute to his conviction rate, I'm sure. Alright, move. Am I supposed to be finding Mr. Grossberg somehow? I'm kind of lost, I think, so I might cut some of this out, depending on how much longer this takes. I'll present him my attorney badge, see what... Okay. Oh, okay, this is the note to... They have to... Okay, we've been over this in the other video. They have to give me everything they're going to use in the trial. They can't... And they have to give me an adequate amount of time to review it before the trial. So they can't just refuse to hand this over. Well, actually, they probably wouldn't actually give me the phone. They would just give me, they would download the phone, and then they would give me a copy of, or at least allow me to review a copy of, depending on what was on it. Sometimes, if the information, such as certain pictures or something on the phone, is illegal in itself to possess, then they could not give me a copy of it, but they would allow me to review it at the police station. Is correct. I can't influence the witness, or I'm not allowed to influence the witness. I absolutely am allowed to talk to the witness. And again, they would have had to have told me who all the witnesses were before we could even get close to a trial. Witnesses don't have to talk to me if they don't want to, if they're not actually employed by the state. So like the police, they can't say, no, I'm not talking to you about it. But like they don't have any control over a third-party witness who just who just reported a crime. So I have the right to attempt to talk to them. They do not have to talk to me if they don't want to. That's entirely up to them. But the state cannot try to stop me. Okay, you can't confine her just because she witnessed a crime. But, I mean, she'd be told not to leave town if she's from out of town or whatever, because they're going to need her, but, yeah, you can't confine her to the hotel room. Unless it's some kind of protective custody, but as far as I'm aware, there's no reason to think that she would be in any kind of danger. Well, there is one other reason they could hold her, I guess, which is that if they had reason to believe that she would not be available for trial, you can get what's called a material witness warrant, which is based on a particular witness's testimony being essential to the case, and you don't believe they will be available based merely on a subpoena. That does require a judge to sign off on the warrant. The police can't just do it. And typically, when I have had that happen, it's been someone who has been subpoenaed, but the subpoena, they haven't showed up for the time they're subpoenaed for. So then, you know, you get a warrant for their presence. That's pretty rare. Usually if someone's not showing up voluntarily, they're probably not going to say anything very helpful to you anyway. But sometimes it's just somebody who doesn't want to be bothered with dealing with court, and their testimony is necessary to the case. But again, they would tell her not to leave town. She's in a hotel, so I assume she's not from around here. But there'd be no reason to actually hold her in her apartment, as far as I'm aware. Or I mean, in her hotel room. Okay, they can't do that. They cannot tell the police or the witnesses not to talk to me. The state can't. They can tell them that they don't have to talk to me if they don't want to, but they cannot tell them not to talk to me. That is very much not okay. Alright, I'm gonna snoop around her apartment, I guess, while she's getting freshened up. I'm not liking the way these games portray women, honestly, at this point. Between the way the prosecutor was talking about the victim in the previous case and the boss lady, although she at least seemed to be competent, so there's that. This lady, there's some unfortunate depictions of women in these games, but, you know, what are you gonna do? It is what it is, I guess. So, she says, don't look in my stuff. Yes, 100% I shouldn't. We were talking about ethics. If I were meeting with her, which again I would be doing with an investigator, because I want someone else to, or at least some kind of witness who isn't me, so that if we had a contradiction in statements, I would have them to potentially call as a witness to testify as to what this person said. But if I'm meeting with this person and she goes off to do whatever and tells me to wait, I can obviously look around the room that she left me in. I can't be going through drawers. I can't be, invading her privacy in that way. But, anything that was in plain view I could look at because she left me here and gave me permission to be here. So it's all fair game. So, I can see that screwdriver handle, but I couldn't be digging through stuff. Alright, let's talk to her. Ask her what she saw. This would be a very uncomfortable situation. I would get out of there ASAP. Since we're alone, I would not want her to be able to say anything happened that didn't She's clearly, this is not a good situation for me to be in. Again, another reason to have an investigator or other witness with you so you're not alone in this kind of situation. Because especially if she's hostile to you as an attorney, she's the reporting witness, and depending on what she says on the stand, I may be cross-examining her pretty forcefully. You don't want her to have any incentive or leeway to be able to say, make any accusations against you, either of a criminal nature or just of an ethical problem, or even just stuff that would make you look bad. You know, as a lawyer, you kind of live and die by your reputation, so you don't want to put yourself in any situation where that reputation can be tarnished, because it's hard to come back from that. And especially like with the court and stuff, you need them to have confidence that you're being honest. As I said, you have a duty of candor to the tribunal. You have to be honest with the court. You need everybody to basically be able to trust your word. So you got to protect your reputation. Which isn't to say you can't have relationships with people, but you don't want to put yourself in that situation with witnesses and cases, that kind of thing. Anything that would look like you're compromised in a way related to your professional capacity. You know, if you want to do whatever you want in your private life, and that's fine. That's not the kind of reputation I'm talking about. But anything that would call into question your professional standards. Okay, she absolutely can do that. As I said before, she can tell me I'm not saying a damn thing to you. Go pound sand. Again, yeah, I should not be here. I do probably need to talk to this person, find out what they're going to say, since the cops aren't telling me anything. Because I do, as the attorney, I need to have an understanding of the case. But again, I should have someone else here with me. Okay. So, is there anything I can present her? No. She's not gonna let me look around, probably, is she? Oh wait, I guess I'm looking around. Maybe later. When am I gonna be back? So she's okay. And again, as I said, I can look around the room. I just can't be digging through stuff. I can't exactly make sense of that painting, but it looks kind of inappropriate to me. Okay, good to know. So yeah, you can see in the room, but probably not be able to tell individuals, especially if you're not familiar with them. Alright, let's go back and talk to my client now that I have her phone. Alright. Good, they're not playing the whole conversation again. Oh, okay, I thought there'd be more to it than that. Alrighty, I guess I'm gonna go back to... He's even grander? That's a... Okay, not busy is not the same as being easy to get a hold of. He was probably out golfing or something. That doesn't mean he doesn't have time if he feels like it. Yeah, exactly. No one can take cases on a day's notice. It doesn't work that way. Alright, I'm gonna tell Maya that he won't take it. I mean, I don't know what else to tell her. You just said you weren't busy. I don't understand why that makes him a creep. Okay, he's probably being threatened, is my guess. Similar to whoever killed Mia. Or rather, similar to Mia and whoever killed her. There's clearly something going on. Okay. Let's talk to Mia, or Maya. I'm gonna tell her he won't take it. No, okay, I can't be lying to my client. Okay. If she means talking about it to the police, she should not have been talking to the police without an attorney. That's just good advice all the time, but especially since she's been trying to hire an attorney, she should have waited until she had an attorney to talk to the police. I mentioned it in the previous video about the Fifth Amendment right not to give evidence in your own case. You also have a right to be represented by counsel, which includes at all questioning. If you ask for an attorney, they have to either give you one or stop questioning you. The actual Miranda warning says if you cannot afford an attorney, one will be provided for you. That's not strictly true. There are other options. Just say, okay, we won't ask you any more questions. Then they don't have to actually get you an attorney. But if you ask for an attorney, they cannot question you without one. Generally speaking, don't talk to the police without an attorney, unless, you know, if you're reporting a crime in which you're the victim or something, then yeah, go for it. But if you're in any kind of suspect type situation, don't do it. You know, even if you're completely innocent and you know, and you feel like you can explain it, it's always better to talk to an attorney first. They can make sure that your rights are protected, you know, and they may well tell you, yeah, okay, let's go meet with the police and let's talk to them, and get this straightened out. That may be their advice, but you always want to get the advice of counsel before you do something like that. But especially in this case where she's been trying to hire counsel, she should not have been talking to them. Okay, so she gets there at 9. We get the uncomfortably, suggestively posed corpse. Ruined her life, so got her pregnant would be my guess for that kind of euphemism. Okay, police do sometimes do that. I don't think it maybe happens anymore, at least I hope not. But I've definitely heard of it happening in the past, police consulting psychics. It's really a bad idea for them to do that. Nothing they find that way is admissible, and it just makes them look silly, to be honest. A good defense attorney can really make some hay with that. yeah, they keep it secret because it makes them look silly. Time's up. Well, I mean, no, really, I should go home. She should get us a court-appointed lawyer. That would not be a very fun game, though. No, I can't. No, that's not how that works. She has to agree to me to be her attorney. But I could say, I'm willing to defend you because I can't abandon you because... You know. Because Mia was my boss and I want to look out for you. Okay, yeah, and that's a good reason that you want to help people, and that's why you became a defense attorney in the first place. So yeah, she needs help. But a court-appointed attorney with some actual experience probably gonna be better than me. But I also shouldn't have been doing all this investigation. Okay, don't ask your client that. It doesn't matter if they're innocent or not. And you know, you don't want to create potential conflicts for yourself if they say different things at different times. So, yeah, you don't necessarily want to know that. It's a screwdriver. All right. Let's see, is there anything I need to show her? It doesn't show her that. Okay, let's go talk to the lady again, I guess. Oh. Okay, no, I can't just go digging through her stuff. And even if I do, and even if I find anything, it wouldn't be admissible because I would be the only person who could say I found it, which means, again, I'm making myself a witness in the case, which means I can't be an attorney in the case. You need someone else to be your witnesses. You cannot be a witness in the same case where you're an attorney. So I should not be the one looking for actual evidence. Okay. Thank you for giving me a flashback to 30 seconds ago. Okay, let's find out what this mysterious screwdriver is. Oh, shocker, it's a screwdriver. Okay, screwdriver, wiretap, the phone was unscrewed. So... I can't use this evidence, though, because I am the attorney, not the witness. We need a different attorney so that I can be the witness and say I illegally searched this woman's place and found this. Which I can do. It's only the state. So the state, if the police illegally search a place, then with certain caveats, they can't use that evidence, what they find in a prosecution against the person. But that does not apply to private citizens who are not acting at the direction of the state. So I actually could, as a private investigator, I could go illegally search somewhere and then we could use that evidence in court. I might be subject to prosecution for burglary while I did it, but it would not, the remedy would not be exclusion of the evidence. It would just be prosecution for whatever crimes I committed in the course of finding that evidence. But the evidence would still be able to come in. The state has their evidence, if they search somewhere illegally, gets excluded to discourage them from searching places illegally. It seems pretty straightforward. Because obviously you're not going to be prosecuting the police for burglary for illegally searching a place, so the only real remedy is to exclude the evidence so they can't use it. Phoenix, you need to stop digging. Okay, to be continued. Well, I'm kind of torn whether to keep going or not. Okay, day 2 trial. Yes, I will keep going. I'll call this all one episode. Part of the same case. Okay, we're in the same weird courtroom that I don't recognize what the... Oh hey, I've seen that guy on the memes. I should have gone back and talked to my client. I should have gone and talked to the officers some more. Yeah, there was not enough preparation in this case. Not even remotely enough. I had assumed in the prior case that we had done all that off screen, and that was supported by Phoenix's statement that he had read the case report cover to cover a whole bunch of times. This case, not so much. I know what we've done, and it is not enough preparation. Okay, so I guess this is opening statement. Okay, that objection, Your Honor. Counsel is commenting on the evidence. When you're making argument, you can say what the evidence is. You can recap, or well, in this case, opening argument. You can say the evidence that you reasonably expect to come out in the trial. You can say the state will introduce evidence to show that Mia was murdered, that Maya was found at the scene, that she was bludgeoned to death with this object. You know, because you know what your case is going to be, and you expect all those things to be true. So as long as you reasonably expect the evidence to come out that way, you can say what it's going to be. You cannot comment on the strength of the evidence. So you can say, well, that's not even... You can comment on the strength of the evidence. You cannot comment on your own opinion, which is a fine line. But so you can say, she was the one found at the scene immediately after the murder. Therefore, you have to conclude she's the one who did the murder. But you cannot say, I think she is guilty. It's the I, or in this case, the prosecution, but you're the prosecutor. You cannot state what your opinion is of the facts. It's a silly distinction, quite frankly, because everybody knows what the prosecution's idea is. Everyone knows what they think, because they wouldn't be bringing the case if they didn't think, at least ideally, they wouldn't be bringing the case if they didn't think this person was guilty. You assume that they think the person's guilty, but you still can't say it in that way. You cannot express your own opinion of the evidence. You can only recap the evidence and argue reasonable inferences that can be drawn from that evidence. Okay, yes, this is so prosecution goes first, like we talked about last time. Call the officer. That is normally how that would go. Depending on the length of the trial, sometimes I'll call each witness once. Sometimes I'll go in a kind of a chronological order and pull them in and out as they come in and out of the story. But either way, yeah, starting with the main investigator is a very common. That's a normal way that you would do that. And yes, first question to almost every witness I ever put, or to pretty much every witness, is I say, can you please state your name for the record? And they say, Officer Gumshoe, which the lawyer joke is, oh really, your first name is Officer? But he would say, whatever he says, he would say his name. And then I would say, and how are you employed? And he would say, I'm a detective with the whatever city we're in police department. So yeah, you do establish that. So far, we're actually going... Hey! He answered his name right! His name is Dick Gumshoe, not Detective Dick Gumshoe. Thank you. You did better than a lot of police officers do on the stand in real life. Okay, and that was the next question. Technically, that would be objectionable as a compound question. You can only ask one question at a time. No one would object in this case because it's preliminary, just kind of getting basic information out of the way. Who are you? What do you do? But technically, I could have objected to that. But again, no one would, because you're just being difficult at that point. It doesn't accomplish anything. Okay, so a couple of problems here. One, we have not yet established that there even was a murder. So objection, assumes facts not in evidence. That fact being there was a murder. That fact is not in evidence right now. 2, kind of asking to testify in the form of narrative. I went into a little rant about this in the last video, but basically you can only ask a specific question and get a specific answer. You can't just say, tell me what happened to go. 3, he's about to use some kind of demonstrative exhibit, it appears, a floor map. That is not a problem in and of itself. The problem is it has not been admitted into evidence. But this is actually a realistic problem that comes up where officers want to, or not just officers, witnesses in general, they want to refer to things, documents that they have or whatever, that have not been admitted into evidence. So what I would do in this situation is I would say, let me stop you there. Floor map. What is this a floor map of? And he would say, the office where the murder occurred. And I would say, okay. How did you get this floor map? And he would say either I drew it based on my measurements, or it's rough not to scale, but I drew it based on my observations, or he would say I got it from the building plans, or whatever. He would say where he got it from. And then I would say, can I please have that? And is it alright if I mark on this? And then I would put an exhibit sticker. I would say, I would mark this is State's Exhibit 1, and I would hand it back to you. And that way we can always refer to it. It'll go into the record as State's Exhibit 1. I wouldn't admit it yet at this point because it's just a map. But after he explains whatever he explains about it, then I would ask to admit State's Exhibit 1. So that way, the court, if they need to take a recess to review things before they make a ruling, or if there's an appeal and an appellate court needs to look at it, they can refer to the State's Exhibit 1 and they can refer to the testimony and they can see what we're looking at. But yeah, so I really highly doubt any of that's going to happen, but that is how you would do something about that. And then yes, then I would say, okay, so describe the scene. What is this showing? He would say, okay, the body's found here. Objection, Your Honor. How does the witness know the cause of death? Is the witness a doctor? This officer can only testify as to what he observed and what he is qualified to conclude from that evidence. So if he's a doctor who can do an examination, then fine, he can say what the cause of death was. Otherwise, we're going to have to go into the autopsy for that. The coroner or the medical examiner, depending on what your jurisdiction has, would have made a report, an autopsy report that says what the cause of death was. That person would testify. We would enter that report into evidence. And then this officer would be able to talk about how they, after getting the coroner's report, they concluded it was struck with a blunt object, that it was cause of death was a blunt object. Now, we can kind of get around a little bit of that by, at this point, instead of saying, what was the cause of death, you can say, did you see any apparent injuries on the body? And he could say, yes, her head was bashed open and there was a lot of blood on the back of her head. So he's not saying that's what killed her, but that's obviously suspicious. You don't have to be a coroner to know that that is suspicious and that you should be looking for a blunt object covered in blood. So it's a technical point, but it's an important one. You can only have people testify about what they're qualified to testify about, and he is not qualified to test, or at least nothing has established that he is qualified to talk about her cause of death being due to blunt force trauma from an object. Okay, again, he can't be saying that's the murder weapon. I would probably say speculation. Objection, Your Honor, the witness is speculating. He can say, we found a statue covered in blood near the body that is consistent with, and then I, as the prosecutor, would say, and was that object consistent with the sort of injuries you observed on the body? And he would say yes. Like, we can say that, but he cannot actually say this was the murder weapon. He's not qualified to make that actual determination. He can only talk about what he observed. And then it's to the jury, which obviously the jury wouldn't have much trouble drawing that conclusion, but that's for the jury to... That would actually probably be the better objection, would be objection invades the province of the jury. Meaning the witness is saying something that is for the jury to decide, not for the witness to say. And yeah, okay, yeah, it was heavy enough to be a deadly weapon even in a girl's hands. Okay, yes, and I had a case where somebody was threatening someone with they had a chain, a metal chain, and they were swinging it around like they were going to hit somebody. And I asked the officer how heavy was the chain, and we had kind of a back and forth where it was hard for them to really articulate. And finally I just asked, was it heavy enough that it could seriously injure you if you were struck by it? And he said yes. That's the kind of thing a witness can say. Whether or not you're going to get hurt by being hit with something, that's something within everyone's common experience, so that's something anyone's qualified to answer. He observed the chain. He could see whether or not that chain was something that could hurt you. So this is a statement, this would be fine. It's only the statement that it was actually the murder weapon that's a problem. Okay, and we didn't mark that exhibit like we should have, but actually this is the first time I think that we've gone through the proper steps of getting an exhibit admitted, which is I found a body, I found a statue covered in blood, this is the statue, move to admit the statue. That is the correct order of things, so they actually did pretty good there. I'm going to say objection, that's conclusory. Hard evidence that she did it is a conclusion. He would need to be more specific about why he arrested her. Yeah, the judge is kind of getting at that same idea. Okay, so he shows up, there's me and Maya. Okay, because of the witness. So yeah, you'd say, why did you arrest Maya? Well, I had a witness that reported she saw the murder, and Maya fit the description of the reported murderer, and she was found at the scene. That is a perfectly coherent reason to arrest her, and it doesn't require any commentary on the strength of the evidence or anything like that, and it answers the question. Where is Maya anyway in relation to me? Okay, this is actual good advice. A lot of times, especially my practice as a prosecutor, is to go over things, hit the important points, and then leave it. Get what I need, and then get out. And the defense attorney, it's good advice for them to get up there and then ask every little detail about what the person said, because sometimes you may not notice the contradiction when you're talking about things in general terms or in pretty broad overview terms. But when you drill down into stuff, there might be problems that you come across. So yeah, that's good advice. Is you just want to make sure and you dot every I and cross every T, just to make sure that you've fully covered your bases. And again, if that woman presumably is lying about Maya being the murderer, so that doesn't necessarily mean anything this detective said is incorrect. So there may not be any contradictions to call out. Okay, so a lot of times a witness might say something like, did I say that? Or ask a question like that. No one else in the courtroom can really answer them. In this kind of situation, what I could do is ask the court reporter to read back that part of the testimony So then the court reporter would look back at the record and read back the relevant part where the person said the thing. But other than that, no one else can actually answer that question and tell them what they said. Okay, so he said he had hard evidence, but he really just has a witness statement. Kind of splitting hairs there. Witness statements are evidence. Whether or not they're hard evidence is, that's a semantic argument. Hard evidence is not a legal term. It doesn't mean anything specific in a legal context. I understand where they're coming from, that to me hard evidence sounds like physical evidence or verifiable evidence, like maybe a videotape or something, not just somebody's statement. But a statement from a witness is evidence. So we're just arguing characterization of it here. Okay, yeah, so we found this, and like I said right at the beginning, that does not look good for a girl. Okay, objection, Your Honor. Witness is speculating. He can't say that it was the killer's name. He can say that this blood belonged to the victim and that it spells out this name. That he can't speculate as to why she wrote that name. That's for the jury to do, and yeah, they're going to draw the obvious conclusion that she was writing her killer's name, but this officer can't be saying that. Again, we were already doing cross-examination. We're not beginning it. That would be for me to ask as the defense attorney. Why didn't you bring that up the first time? Okay. Now see, that's not a real objection. I talked about this in the previous video. I don't have to prove anything. I just have to call into questions. So, just because you found it next to the body, how do you know the victim wrote it? That's a perfectly valid question. He can say, who else would have written it? And I would say, maybe the killer. You can't object. And I would have to kind of turn that into a question. I would say, like, why couldn't it have been the killer? But you can't object that I don't have evidence of that. I'm questioning the witness's conclusion that it was the victim who wrote it, and I'm just offering potential alternate explanations to call into question that conclusion. I don't need evidence that those are true, because he doesn't actually have any evidence specifically that his version is more likely true than my version, so I'm just pointing out other equally valid explanations. So yeah, there's no objection to be had here. Blood was that's a better answer. That's how I know the victim wrote it. But even then, obviously, the killer could have written it in the victim's blood. Blood found on the victim. Yeah, it's... I talked about last time. This is all circumstantial evidence, but it's pretty damning circumstantial evidence. I'm not really sure what they want me to press on here. Okay, so secure the suspect. Okay, found the memo. I'm gonna try, I guess, presenting the memo, see what that does. Yeah, I don't understand what the game wants from me here now. Okay, yeah, Maya was clearly written in blood. Lab test showed that blood was the victim's. Also, there's blood on the victim's finger before she died. In books and the movies, yeah, exactly. It's not a movie detective. Oh god, that was great. That was some pretty great rhetoric there from Phoenix. I have to say that I like that. Hey, that's actually true. Kind of. So, yeah, the victim, only experts can testify as to their opinions, and only within the within the confines of what they're an expert for. So, like, technically the medical examiner saying this was the cause of death, that is a medical opinion, but they are qualified as an expert, so they get to express that expert opinion. Witnesses in general cannot express their opinions except in narrow things where it's relevant. But in this case, I'm not really asking for his opinion. I'm not saying, is it likely? That would be his opinion. What I can say is, what I did say, in your experience, is this normal? Does this often happen? And he would say no. And so, in your experience, this is unusual. Is that correct? And he would say yes. Those are factual things. It's not common. It is unusual, based on his experience as a police officer. So, yeah. So he's right. The witness's opinion is irrelevant, but we're not getting opinion testimony right now. So, again, that's a conclusion, not a fact that the victim wrote the name. Objection, Your Honor. Counsel's testifying. After securing the suspect... I really am not sure. Lab test. Okay, that's awesome. Yeah, so he says lab test found that it was the victim's blood. So presumably they did DNA testing. But yeah, the fact that he doesn't understand it, you can really make a witness look dumb in that kind of situation, which does not help their credibility. Okay, so one important thing that this game seems to not be acknowledging is that a lot of times there's not really anything to call into question in a particular witness's testimony. You might want to point stuff out like, oh, that information is not specific to the defendant, but there's not really necessarily anything to call into question. Like, I went to my storage unit and the lock was cut off my storage unit and there was stuff missing from my storage unit. Like, as a defense attorney, there's nothing really to question there. You just, kind of make the point, well, you didn't see anyone break into your storage unit, did you? No. Okay, so you don't know if it was my client or not. Like, yeah, there's not always something to question. Sometimes stuff is just factual, and you need to move on. I wish this game would let me move on. I might edit this down. Oh, right, we already went through this. How do I end this? Let me escape this purgatory. Examined it with the own eyes I found. Okay, I'm just gonna keep going through and... There has to be a contradiction. Okay, 9. Okay. So the time of death was 9. Death was instantaneous. Let's look at the... So there was a struggle. Starting at the desk, ended with her in front of the window. Okay, I'm gonna try presenting the phone call. Alright, I'm just gonna look this up. Oh. Okay, I'm an idiot. Present. Death was instant. Okay, again, not an objection, but I'm gonna, if I mention that every time, I'm gonna go crazy. Just whenever they say objection, it's not actually a real objection. Except occasionally, I guess, when the 1-1 is, but it's still wrong. So. Again, okay, Judge, don't comment on the evidence. And also, that report hasn't been admitted into evidence yet. But regardless, don't comment on the evidence. You can't say that. I got it the day after the murder. Okay. Time to move for a mistrial. The prosecution would absolutely have had to turn over that information to us. They cannot present surprise evidence. The defendant is required constitutionally to be made aware of the allegations against them. That includes the evidence against them, so that they can mount a defense. You can't just give new information like this. At best, so sometimes you do get information like last second, but you have to make defense aware of it as soon as you become aware of it, or as soon as you can afterwards, and then they need an opportunity to review it, to potentially ask for a continuance of the hearing, so that they can review it and make whatever decisions they need to make. But you can't just use it like this without them knowing about it ahead of time. Even so, we talked about how this guy forges evidence. Even if it's forged, he still can't admit it without having given it to me ahead of time. Yes, thank you. That is one of the first correct things I've heard from the judge. Yes, Judge, you're right. The defense, you cannot personally attack opposing counsel. And again, as I always say, that's not how evidence works, but the lawyer can't just give it to the court. You gotta have a witness. Objection, Your Honor. You can't describe the witness like... I don't even know exactly how you'd phrase that objection, but yeah, he can't comment on the witness's character like that. Poor innocent girl. Okay, Phoenix, don't be so judgmental. She's allowed to want to have fun. And just because she may like to flirt does not mean that she needs to be watching murders. That's going to be traumatic for anybody. Wanton winking. Okay, yep, so we're just... Well, why is a judge interrupting all of a sudden? Okay, same problem, testifying in the form of a narrative, but yeah, that's, I think, gonna probably happen with every witness. Okay, so she established the time, where it was, she identified the defendant, which is important. You would be doing this all with specific questions, but you would say, the way I often say is, on such and such a date, did you have any contact with the police? Yeah, what led to that contact? But, yeah, I would say, you know, what did you see? You saw, you know, a girl with brown hair bludgeon the victim to death. Do you see that girl in the courtroom here today? She would say yes. I would say, can you describe what she's wearing? She would describe it, and then I would say, Your Honor, I would ask that the record reflect that the witness identified the defendant. That's and then the judge would say the record shall so reflect. That's all just so that, like, if this goes on appeal later, because one of the important things is the state clearly has to prove not just that a crime was committed, but the defendant is the one who committed the crime. And if you have an eyewitness, you have to prove that the person that the witness saw is the same as the defendant. And so, you know, in a courtroom with everybody there, they could just point and everyone can see who they're pointing at, but that doesn't go down on the transcript, so you have to get something in the transcript that then an appellate court judge could look at and still tell who they're referring to. So you just say all that, so then the appellate court can be like, yes, okay, so they identified the defendant, so the state satisfied that requirement. At least in a technical sense. They may not have proved it beyond a reasonable doubt, but they at least did establish that fact. Okay, so I think it's going to be important that she can't actually see the desk, if I'm reading that diagram correctly. The white cone is her field of view, and she can't actually see the initial struggle on the left. She can only see the last bit. Okay, no, that's not up to the judge. You always get a cross-examination. The judge cannot comment on the strength of the witness or the testimony or the credibility of the witness. You can't say, yes, this person seems very believable, or no, this person is obviously lying. You can't say anything like that. You just, and the defense always gets a cross-examination if they want one. They don't have to take it, but they always get one. Cowardly way. That's the defense is literally, that's their job. To find faults in the testimony and create questions. Yes, I'm gonna cross-examine her. I'm not gonna waive that. Okay, so she looked out the window at 9. Saw a woman with long hair being attacked. Dodged to one side and ran away, and she hit her. Okay, so saw a woman with long hair being attacked. She dodged to one side. I guess I'm just gonna press everything. Again, I question the again, you can't. The prosecution can't be commenting on how solid the testimony is. Okay, now I'm testifying. The state should be objecting. Your Honor, counsel is testifying. I cannot testify. If I want to establish what she was wearing the night of the murder, I would put her on the stand. Or I'd recall that detective and say, what was she wearing when you arrested her? But, yeah, I can't be testifying about it. Yes, Detective Gumshoe. That's much more relevant. Okay, omit nothing. Obviously that's impossible. You cannot describe literally every aspect of anything that you saw. You're always only describing the relevant aspects, and what's relevant is going to be different from one person to another. So clearly she's covering. That's not a very convincing explanation, but that's not really a sensible admonition from the judge either. ran off to the right. The girl in the hippie clothes. I did see everything. The victim, the woman, dodged the first attack, so she ran to the right. And then the girl, she ran after her. Okay. I'm gonna press her on this. The hell would you? Dodge the first attack. Okay, I'm gonna try and present the glass shards. Okay, I'm probably gonna lose. So the first attack was off where she couldn't see. I'm not sure how to prove that. Okay, so I'm supposed to press. Of course, that's the thing that they say, refrain from personal attacks. Dodged. I'll just press on everything, I guess. Okay, yeah, so it's gonna be the same point. How do you know this is a clock? I'm sorry, there's not a lot to say in this part. I'll probably, I keep saying this, probably shorten it down. I can't object to what the court says. I mean, I can, but that's not the kind of situation where I'd do it. Objection, Your Honor. Counsel's testifying. Jesus. Lots of clicking through. Was that admitted into evidence? I don't remember. I think it was. Okay, yeah, it was admitted during the detective's testimony. So, okay, that checks out. We can examine it. Objection, Your Honor. You can't characterize her as a liar. You can say that she lied. Even that's pushing it, but you definitely cannot say that she is a liar. You can say that what she said wasn't true. You can maybe say that she is lying in this situation, but you cannot call her a liar. You cannot attack her or her character like that. I can, in fact, prove it because of the phone call. Take that! This is, again, not at all how evidence works. I would need to put my client on the stand to authenticate the phone, or put the detective on the stand to say this is the phone that he got from the defendant. Counsel's testifying. Just can't get into evidence. That's my constant refrain in this game. I sound like I'm upset. I have a smile on my face this whole time. This is fun. This is ridiculous and amusing. Yeah, it didn't seem like the detective was really, like, he was telling witnesses not to talk to us, and he was kind of hostile to us, but he wasn't a bad guy. And it sounds like that the bad stuff about, like, telling them not to talk to us, that sounds like it was coming from the higher-ups more than him. So, yeah, I kind of don't want him to get in trouble. Poor guy. Okay. Okay, I suspect the game... Oh yes, because it was made by yeah, it was made by Larry. Everything is sold in stores. How old is this game? Nothing's sold in stores. Everything's sold on the internet. Ho ho ho, how funny, Mr. Phoenix Wright. I enjoy your quips. Is her shirt going to explode? Yeah, she is hulking out. Boobs are hulking out. Whoa. Objection, Your Honor! She's... I guess saying what the sentence should be, which she's not allowed to do. But really, I wouldn't object to that, because she's clearly just going crazy and making herself look bad for the jury, so that's really more helpful to our case than anything she could actually say being harmful. Oh, she unhulked. Do I have an opinion on this behavior? I'm guessing you held it. Yeah, that doesn't actually make sense because the clock wasn't working. That was not the argument I was trying to make. Phoenix, why you do that? It doesn't matter if she did it. Her testimony was torn to shreds anyway. Okay. You can't just say that the bellboy corroborates the story. You have to call the bellboy and he has to corroborate it. Aha, right, she had the wiretap. Again, counsel's testifying. Stop testifying. Counsel's testifying. It's not irrelevant. I don't have to prove anything. The same recording I already played. I love how they smack the table every time they object. That's my favorite part of this game. Is her brain broken? Okay, it's not irrelevant. She tapped the murder victim's phone. That clearly is related. Yeah, or not. If not related, it's at least suspicious enough that it's worth investigating and determining if it's related. So yeah, not irrelevant. I didn't accuse you of killing her. I specifically did not accuse you. Okay, yeah, we'll call the bellboy. Why? We don't know that. No, I can't do that. I can't agree that just because... Okay, if my options are accept or give up, then I'm gonna accept, but yeah, no, just because her alibi is true doesn't mean... Like, I've already showed that the rest of her testimony was a lie, and that is the only... Other than some pretty weak circumstantial evidence against the defendant, that's the only real reason to... Her testimony is the linchpin of the state's case, so I've already basically won. Even if I hadn't basically won, it's pretty much textbook malpractice to admit that your client is guilty based on some arbitrary condition. Yeah, so that's not how that would go at all. Also, he doesn't have any basis to object to the bellboy being called. He may argue that it's irrelevant, but the judge clearly agrees that the whole wiretapping thing is suspicious and worth exploring, so his objection would be overruled regardless of any arbitrary conditions he wanted to put on it. So yeah, that's not how that works. We're just creating artificial stakes here, which my client's already charged with murder. I don't really know why we had to up the stakes further. Why does he have the T set? He is totally looking down her blouse. And again, normally, so we have a defense that we refer to as the some other dude did it defense. That is the most common criminal defense. The I didn't do it, somebody else did it. Normally you're not disputing that a crime occurred. Like if a burglary happened, it happened. You're just saying you're not the person who did it. But when you're doing a some other dude did it defense, you're not claiming, you're not, I mean sometimes you are. Sometimes they're like, no, it was this specific other person. But even if that's your claim, you don't have to prove it, and most of the time you don't have another person. You just say it was not my person, it must have been someone else, I don't know who. You're not trying to prove that it was someone else, and normally it's not the person reporting the crime who secretly committed the crime, as seems to be the pattern in these games. Or these episodes. I believe I received. Let's press on that. Ooh, who's them? It's an endearing mannerism. Yeah, I think you're absolutely right. She was creating an alibi. Shocker. He said them. There was more than one person. Okay. And now see, with that kind of thing, defense gets a lot more leeway than the prosecution to explore things because, like I said in the last video, our legal system is all about protecting the defendant's rights. You have to make sure, if you're cutting off defense attorney from potential avenues of questioning, that potentially creates problems that might lead to a reversal on appeal because you're stopping the defendant from adequately defending himself. So, with the prosecution, they are bound by, everyone's bound by the same rules of evidence and everything, but the prosecution, the fair trial for the defendant works against giving the prosecution leeway, because if you let them go off the leash, then they might get in stuff that really shouldn't have been gotten in, that goes against the defendant and is bad for the defendant. Whereas the other way around, when the defendant is the one asking the questions, you want to make sure that they get to explore all reasonable defenses, so that you can make sure everything got out and they can't claim later that they were denied a fair trial and that they need to have their conviction reversed. So this kind of is true. Objection, this has gone on long enough. That can apply to a defendant, but they have to go a little further than the prosecution would to have that kind of thing. I'm going to ask him about check-in. Yeah, there were two people. I object, that was objectionable. Sorry, you need a more specific reason than that. Even if it is objectionable, you have to state what your reason for the objection is. That's not actually true. You didn't ask, unless they like really danced around it. They only need to answer the questions you asked. If they don't, that's on you for asking a bad question. My favorite thing is the Bill Clinton, that depends on what your definition of is. People always accuse him of lying for that, because he was asked, is there a relationship with Monica Lewinsky? He said no. The reason he said no is because that relationship had already ended, like, I believe 2 years earlier, if I recall correctly. Doesn't matter, it was already over. So the question was, is there a relationship? He truthfully said, no, there is not a relationship. They did not follow up and say, has there ever been a relationship? If they had, and if he had said no to that, then that would have been a lie. But he answered the question as asked. He was a lawyer. When you're asking lawyers questions, you want to make sure you're asking the right question. And this is not a defense to what he did or the political situation, but as far as the perjury allegations that he lied under oath, he truthfully answered that question. It was a bad question. And that is an example of why you need to be careful when you're asking your questions. You need to ask what you actually mean. And if it seems like there's a hole in what you asked, or they answer in a way that leaves something open, you need to follow up and make sure you clarify what exactly the facts are, just for that exact reason, because people are not expected necessarily, they're expected to fully answer the question asked, but only the question asked. They don't need to divine what you're trying to get at and answer all other forms of that question or all other related information. You don't just volunteer it. You ask what you ask, and you get the answers that you asked for. And if you don't ask for the right questions, then that is on you. That's not on the witness. He never asked. It was clear that he changed his story, so that's a shady thing. Earlier when he was answering, he said them, and then he changed what he was saying. So he was clearly trying to cover for it, but Phoenix never asked a question that actually required this witness to divulge that there was more than one person. Now, granted, once he did start to say, and then he kind of backtracked and covered up for it, that wasn't right. But he could have, without that, if he had just never mentioned the other person, that he would have still perfectly answered all of our questions. So this is not on him, that's on Phoenix. Wait, did he just call me a barrister? I'm not a barrister. That's an English thing. We are attorneys, we are lawyers, we are not barristers. Future Ethan here. In editing, I just realized something I didn't talk about, and luckily I have some silence to do it. He just said the prosecutor told him not to talk about the other guy in the room unless he was specifically asked about it. That's called coaching the witness. A lawyer cannot tell a witness what to say. You can prep a witness by going over what they can expect, but you cannot tell them what to say. You can't tell them not to talk about certain things. You can't be doing that. That's coaching a witness. That is an ethical violation. That was weird. I didn't really... I hesitated there because I wasn't sure I exactly understood what it was asking, because it seemed so obvious who we were talking about. I wonder if that was more ambiguous in Japanese. Okay, so wait, are we doing more investigation? Okay. Okay. Oh, okay, we're just breaking until tomorrow, so that was just the end of the day. Okay. So... what my concern was I thought the judge was suspending the trial and sending us out to go do more investigation. That's not a thing that you can do. Once a trial has started, the phrase is jeopardy has attached, and that's related to the idea of double jeopardy. Once you are charged with a crime and a trial has started, you are placed in jeopardy, meaning that you are subject to potential legal consequences, such as imprisonment or fines or whatever. Once you're placed in jeopardy, you can never be placed in jeopardy again for those same offenses. So once a trial has started, unless there is a mistrial, which is a specific kind of error that says the trial is invalid, and that's only for legal reasons. So if there's a legal problem, then you can have a mistrial. But once you're placed in jeopardy, you cannot be tried again. So you can't stop a trial in the middle and then say, go investigate more, and then figure out what you want to do. You're stuck at that point in trial. So you can't say, we're going to stop and then follow up on these leads or whatever. Now, but it sounds like we're just continuing the trial. We're just breaking for the day. That obviously, if a trial takes more than one day, then yeah, you're going to break overnight. You're not going to stay there. So that's what I was concerned about. That I thought some shenanigans were happening, but no, it seems like it's just breaking for the night. And then yes, if you break for the night, then the attorneys might go investigate. If information came out that there's some other witness that they didn't know about that they need to get, they might go try and find that person or whatever. Okay, that said, there's only one part that hasn't been stricken from the record. Okay, you only strike things from the record for legal reasons. If someone lied, their lies are still in the record, just so is the part where you figured out they were lying. Striking something from the record is like, if I object, and before the court can rule on my objection, the witness answers the question anyway, then the answer will be stricken from the record, meaning it is not part of the record. But even then, it still kind of is part of the record. It just means like well, for judges, they know not to consider it, and for the jury, if the jury asks for part of the transcript, then it will be left out of that. But unless there's some legal thing like that, like just because someone was lying and then caught in a lie, you don't actually remove the lies from the record. To be continued. Okay, well, this has been running, I think, longer than my previous episode, so I am going to end it here, and we will come back, hopefully in a few days. I'm not 100% sure yet on what the schedule is going to be for these to post, but hopefully it won't be too long, and we will find out what happens in the dramatic case of the Turnabout Sisters. I hope everybody had fun. I will post, if I can figure out how to do it, I will post a link either to the first episode in case you missed it, or the playlist on my profile that has all of the episodes in this series in it. Be sure to subscribe so that you can get the notification when the next episode goes up with the second half of this case, and I will hopefully see you then.